Question number 251. Which one of the following is not mentioned as a ground under section 24 rendering a confession by an accused person irrelevant? Option A, inducement, option B, promise, option C, deceit, and option D, threat. Here question number 251, correct answer is option C, deceit. It is not mentioned under section 24 regarding a confession by an accused person. Question number 252. A rustic woman is in apprehension of assault and maltreatment makes a confession for murder of her mother-in-law at a village panchayat. Whether this confession is admissible, option A, as extrajudicial confession, option B, inadmissible due to involuntariness, option C, as a supporting evidence to the fact deposed by the other witness, and option D, partly admissible. Here correct answer is option B. Question number 253. In which section of Evidence Act 1872 confession is made to the police is not admissible? Correct answer is option A, that is section 25. Confession made to a police is not admissible. Question number 254. Confession before police will be proved, will not be proved, will be considered confession, will not be considered confession. Here correct answer is option B, that is will not be proved. Question number 255. A commits a crime and goes to the police officer. He makes a confession and gives other information. A is charged with the offense. The confession, option A, cannot be proved against him because of section 25 of the evidence. Option B, can be proved against him because of section 27 of the evidence act. Option C, can be proved against him because of section 25 of the evidence act, and option D, cannot be proved against him because of the section 27 of the evidence act. Here correct answer is option A, cannot be proved against him because of the section 25 of the evidence act. Question number 256. A confession to be inadmissible under section 25 of the evidence act must relate to the same crime for which he is charged. Option B, must relate to another crime. Option C, may relate to the same crime or at any other crime, and option D, none of these. Here correct answer is option C, that is may relate to the same crime or any other crime. Question number 257. A confessional statement made before police is admissible, is not admissible, is admissible only if it relates to the fact discovered in consequence of it. And option D, is admissible if it is made on oath in writing. Here correct answer is option B. A confession statement made before a police is not admissible. Question number 258. With respect to the confession under Indian Evidence Act, choose the true statements about the propositions. Article 20 clause 3 of the Constitution protects an accused against testimonial compulsions. Article 20 clause 3 creates no bar in causing retracted confession against the accused. Third, accused can claim protection under section 24 against the confession recorded through compulsion. Assertions here are, in question number 258, correct answer is option D, because all the statements here provided are correct. Question number 259. Which of the following cases is not related to confession? Pulukari versus Kotaya versus King Emperor related to confession. State of UP versus Devon-Upadhyay is also related to confession. State of Bombay versus Kathikalu is also related to confession. The last and the remaining, T.J. Ponnan versus M.C. Varghese, is not related to confession, therefore will be the correct answer. Question number 260. A filed a FIR giving details of a crime that he had committed. There was no exculpatory statements in the FIR and gave all the details regarding the commission of the crime. Which of the following statement is accurate? Option A. The FIR is hit by section 25 of the Indian Evidence Act and hence is inadmissible as evidence. However, the fact that A filed the FIR admissible under section 8 of the Indian Evidence Act. Option B. Since FIR is confessional in nature, the fact that the A is filed the FIR is also not admissible in evidence. Question number statement C. The FIR including confession is admissible under the Indian Evidence Act as it was voluntary and before arrest. Option D. It is admissible under section 32 clause 3 of the Indian Evidence Act. Here only statement A is correct. The FIR is hit by section 25 of the Indian Evidence Act, hence it is inadmissible as evidence. However, the fact that A filed FIR is admissible under section 8 of the Indian Evidence Act. So option A will be the right answer in question number 260. Now let us proceed to question number 261. Confession can be the result of self-talk. Communication of confession to another person is not necessary was held in the case of option A. Sankaria versus State of Rajasthan, option B. Bhutta Singh versus State of Punjab, option C. Sahu versus State of UP, and option D. 𝐚𝐭𝐿𝐴 Jha versus State of Bihar. Here correct answer is option C, that is Sahu versus State of UP. Question number 262. Extrajudicial confession, if voluntary, can be relied upon with other evidence. Reason: extrajudicial confession is a weak piece of evidence. Here both A and R are true and R is the correct explanation of A. This is the correct answer. Extrajudicial confession is a voluntary, can be relied upon the other evidence, and extrajudicial confession is a weak piece of evidence. Both A and R are true statements and they are the explanation of A. Question number 263. When a confession otherwise relevant will become irrelevant? Option A. In consequence of a deception practiced on the accused made to a police officer made under the promise of secrecy when the accused was drunk. Here correct answer is option B. That when a confession otherwise relevant will become irrelevant if is made to a police officer. Question number 264. Under which section of Indian Evidence Act the confession before the magistrate is relevant? Correct answer is option C, that is section 26 of Indian Evidence Act. Confession made before the magistrate is relevant. Question number 265. Extrajudicial confession means a confession made before judicial magistrate in court, before doctor, before friend, before doctor and before friend. Here correct answer is option D, both before doctor and before friend. Question number 266. A confession made by an accused is relevant and admissible. Option A. When it is extrajudicial, voluntarily and truthful and beyond reproach. Option B. When made to a third person after being detained by a police officer. C. When made on being threatened with severe assault and beatings by police. Option D. None of the above is confession is inadmissible. Here correct answer is option A. A confession made by an accused is relevant and admissible when it is extrajudicial, voluntarily and truthful and beyond reproach. Question number 267. In which state a confession may be proved? Option A. If the confession is made before a police officer. B. If the confession is made due to pressure of police before a magistrate. C. If the confession is made voluntarily before a magistrate. And option D. None of these. Here correct answer is option C. If a confession is made voluntarily before a magistrate. Question number 268. A confession made in police custody is admissible under section 26 of Evidence Act. Option A. If made in the presence of a doctor. B. If made in the presence of a captain of vessel. C. If made in the presence of a magistrate. D. None of the above. Here correct answer is option C. If made in the presence of a magistrate. Question number 269. A confession made by a person while in police custody is inadmissible under option A. Section 29 of Evidence, Section 26 of Evidence, Section 25 of Evidence Act, Section 27 of Evidence Act. Here correct answer is option B. Section 26 of Evidence Act. A confession made by a police while in police custody is inadmissible under Section 26 of the Evidence Act. Question number 270. A voluntary confession is admissible in evidence. Option A. When made to a police officer. Option B. When made to a magistrate or competent jurisdiction. Option C. When made to a village sarpanch with request to save him from police. And option D. When made to a police officer who kept him in his custody. Here correct answer is option B. A voluntary confession is admissible in evidence when made to a magistrate of competent jurisdiction. Question number 271. Confession recorded by a magistrate on oath is. Correct answer is inadmissible. Question number 272. Choose the true statement about the propositions. First, judicial confession is substantive piece of evidence. Extrajudicial confession is not a substantive piece of evidence. Confession of co-accused is admissible against other as well. Here options are first and second are correct, third is incorrect, first and third are incorrect and first is incorrect, first and third are correct and second is incorrect. Here correct answer is option C, that is first and third are correct and second is incorrect. Judicial confession is a substantive piece of evidence. It is correct. Extrajudicial confession is not a substantive piece of evidence or weak piece of evidence. This is also correct. Confession of co-accused is admissible. Confession of accused is not admissible against others as well. Question number 273. The term police custody under the section 26 of the Indian Evidence Act means which of the following? Option A. Physical presence of the police before an accused person. B. Indirect control by the police of an accused person. C. Some restrictions by the police over an accused person. D. Some kind of surveillance and restrictions over the accused person by the police. Here correct answer is option D, that is some kind of surveillance and restrictions over the accused person by the police. The term police custody used under section 26 of the Indian Evidence Act means some kind of surveillance and restrictions over the accused person by the police. Question number 274. The term judicial confession means option A. It is made before a police officer. B. It is caused by inducement, threat or promise. C. It is made before any court officer. D. It is made before a magistrate. Here correct answer is option D. The term judicial confession means it is made before a magistrate. Question number 275. A confession is inadmissible if it is made by the accused. Option A. To a magistrate while he is in the custody of a police officer. To his friend while he is not in the custody of a police officer. To a doctor while he is in the custody of a police officer. To a spiritual advisor under the inducement for the good for his soul. Here correct answer is option C, that is to a doctor while he is in the custody of a police officer. Question number 276. What is the meaning of retracted confession? Option A. Confession which is subsequently confirmed. B. Confession which is subsequently assured. C. Confession which is subsequently resiled. and option D, none of the above. Here correct answer is option C, confession which is subsequently resiled. Question number 277. A confession made to the accused person is relevant. Option A, if it is proceeded from a person in authority unless made in immediate presence of a magistrate. B, if it is made by a police officer unless made in the immediate presence of a magistrate. C, if it is made to the magistrate provided the police officer is present. And D, if it is made while he is in the custody of a police officer and is made in the immediate presence of the magistrate. Here the confession made with the accused person is relevant in option D, that is, if it is made while he is in the custody of a police officer and is made in the immediate presence of a magistrate. Question number 278. For recording a confession, magistrate should, option A, get that person arrested, summon the complainant, inform such person about the accusation against him. D, inform such person that he is not bound to make a confession. Here correct answer is option D, that is, for recording a confession, magistrate should inform such person that he is not bound to make a confession. Question number 279. In certain cases, corroboration of confession is necessary. Reason, in all cases, an extrajudicial confession must be corroborated. Here, correct answer is option B. Both A and R are true, but R is not the correct explanation of A. Question number 280. A is an accused, makes a confession to the superintendent of police. In this case, confession made by A is option A, admissible in evidence against A, not admissible in evidence against A. C, admissible in evidence, not will depend on the discretion of the court. D, admissible in evidence against A because A is an accused. Here correct answer is option B, not admissible in evidence against A. Question number 281. Section 27 of the Indian Evidence Act is based on theory of agency, theory of ratification, theory of confirmation by subsequent facts, none of these. Here correct answer is option C, that is, theory of confirmation by subsequent facts. Question number 282. In which of the following cases constitutionality of section 27 was challenged for violation of article 20 clause 3 of the constitution? Here correct answer is option A, that is, State of Bombay versus Kathikalu. Question number 283. Which section of the Indian Evidence Act deals with the doctrine of confirmation by subsequent facts? Option A, section 27, B, section 115, C, section 102, D, section 165. Correct answer is option A, that is section 27. Question number 284. Section 27 of the Evidence Act applies. Option A, when the person giving information is an accused but not in police custody. Option B, when the person giving information is an accused and is in police custody. Option C, when the accused person is in police custody but not as an accused. And option D, when the person is neither in police custody nor accused. Here correct answer is option B, when the person giving information is an accused and is in police custody. Question number 285. Section 27 of the Indian Evidence Act is an exception to the rules enacted. Here correct answer is option D, in section 24, 25 and 26 of the Indian Evidence Act 1872. Question number 286. About 14 days ago, I, K and people of my party lay in wait for S and others at about sunset time at the corner of the Piliput tank. We all beat S and H to death. The remaining persons F, K and N ran away. D, who was in our party, received blows on his hand. He had a spear in his hand. He gave it to me. Then I hid it and my stick in the rick of V in the village. I will show you if you come. We did all this at the instigation of K. From the above passage, which of the following is admissible under section 27 of the Indian Evidence Act? Option A, we all beat S and H to death. Option B, the remaining person F, K and N ran away. D, who was in our party, received blows on his hands. He had a spear in his hand. He gave it to me then. Option C, I hid it and my stick in the rick of V in village and I will show you if you come. Option D, we did all this at the instigation of K. Here correct answer is option C, that is, I hid it and my stick with the rick of V in the village and I will show you if you come. Question number 287. Under section 27 of the Indian Evidence Act, the whole statement is admissible. Only the portion of the statement which leads to the discovery of evidence is admissible. Both A and B are admissible and D, none of the above are admissible. Here correct answer is option B. Under section 27 of the Indian Evidence Act, both the portion of the statement which leads to the discovery is admissible. Question number 288. The constitutionality of which section of the Indian Evidence Act was challenged in state of UP versus 𝐲𝐝 Upadhyay for the violation of Article 14 of the Constitution? Here correct answer is option C, that is section 27. Question number 289. Confessional statement of the accused in custody when admissible if it relates to the confession of a crime by himself, if it relates to the commission of a crime only by the co-accused, leading to discovery of fact relates to the preparation of crime. Here correct answer is option C, leading to a discovery of a fact. Question number 290. B is found dead having suffered injuries with a sharp weapon. A, while in police custody, confessed to killing B with the motive of stealing his motorcycle after following him from his office and having concealed the weapon in office. A gets the knife recovered from before the police. In this case, under section 27 of the Indian Evidence Act, the following would be admissible. Option A, entire statement of including motive of stealing the motorcycle and a manner in which the murder was committed, that is following the victim B from his office except the confession. Option B, the place from which the knife was produced and the knowledge of A leading to the recovery of knife. Option C, the fact that A had murdered B with the knife. Option D, nothing is admissible as the statement was made to a police officer and A was arrested. Here in this question, option B will be the right answer because it is leading to some discovery of fact. The place from which knife was produced and the knowledge of A leading to recovery of knife. Question number 291. If an accused voluntarily consents for brain mapping and narcoanalysis, then such information is relevant under which section of the Indian Evidence Act? Correct answer is option C, that is section 27 of the Indian Evidence Act. Question number 292. In which of the following judgment Supreme Court ruled that section 27 is an exception to section 25 and 26 of the Evidence Act? Correct answer is option A, Inayatullah versus State of Maharashtra. Question number 293. Essential requirement for an application of section 27 of the Evidence Act are: person giving information must be an accused of any offence, the person must be in police custody, the person may or may not be in police custody, A and B both. Here correct answer is option D, that is A and B both. Person giving information must be an accused of any offence, the person must be in the police custody. Question number 294. During the course of investigation, information received from an accused who is in police custody leads to the discovery about arms, clothes, ornaments, corpus, which are related to which of the offence are relevant under section 27 of the Evidence Act. The principle was laid down in the case of option A, 𝐴𝐿𝐼 versus Emperor, Kaushal Rao versus State of Bombay, Sawal Das versus State of Bihar, and Pakla Narayan Swamy versus Emperor. Here correct answer is option A, that is 𝐴𝐿𝐼 versus Emperor. Question number 295. Section 27 of the Evidence Act in respect of the confession evidence. First, so much that the information as it relates to distinctly to the fact discovered in consequence of information received from the person accused may be proved against him. Statement second, person giving such information must be accused of an offence. Statement third, accused need not to be in the police custody. Statement fourth, any statement of the accused confessing his guilt must be made in the presence of a magistrate in all cases. Whether anything is discovered or not in the consequence of such statements may be proved against him. In question number 295, correct statements are statement first and second. Statement first and second are true. Statement first is, so much of the information as it relates distinctly to the fact discovered in consequence of information received from the person accused may be proved against him. Statement second, person giving such information must be the accused of an offence. Statement first and second are true. Question number 296. In which case it was propounded that section 27 is an exception to section 24, 25 and 26. Correct answer is option D, that is State of UP versus Deoman Upadhyay. Question number 297. Section 27 of the Evidence Act applies to discovery of some fact which: option A, the police had not previously learned from other sources and was first derived from the information given by the accused. B, a police had not previously learned from the other sources. C, the police had previously learned from the other sources and the accused has also given information regarding the same. D, all of the above. Here correct answer is option A. Section 27 of the Evidence Act relies to the discovery of some fact which the police had not previously learned from the other sources and was first derived from the information given by the accused. Question number 298. An accused in police custody informs the state house officer that the key by which he opened the safe and committed the theft is kept by him in the patio of how? To what extent this information can be proved? Here correct answer is option D, for keeping the key in the patio of the house. Question number 299. In which of the following cases the Supreme Court held that any information or material that is subsequently discovered with the help of voluntarily administered test result can be admitted in accordance with the section 27 of the Indian Evidence Act 1972? Here correct answer is option A, that is Selvy versus State of Karnataka. Question number 300. Under section 27 of the Evidence Act, the fact discovered means the object produced only, the place from where the object is produced only, the knowledge of the accused as to the object and the place, and none of these. Here correct answer is option C, that is the knowledge of the accused as to the object and the place.